Hey guys, Robert Weir. Today I'm going to be talking about evidence inside of the court of law and like evidence as a police officer. This could really help you if you're a police officer or if you want to become a police officer. Okay, so firstly, evidence can make the difference between winning or losing a case in court. The lesson discusses what constitutes evidence as well as different types of evidence, sources. It details specific rules of evidence and outlines the evidence is admissible and advisable in the court of law. Upon successful completion of this lesson, you will be able to recall evidence types, characteristics, and sources, and recall factors that determine when evidence may be introduced in legal proceedings. Alright, so importance of evidence. The purpose of evidence is to discover the truth about an occurrence. Evidence is whatever enables an investigator to arrive at the truth. Evidence links a suspect to a crime. Evidence exists in the facts of any occurrence. So uncover the facts. This term, evidence, is used in court proceedings. Court decisions are based on evidence that either proves or disproves the facts of an occurrence. Evidence is the foundation of arguments presented by both sides during a trial. So evidence is very important in the court of law. Evidence in itself cannot be considered proof. It is means of establishing proof. Proof is what results from sufficient, credible evidence being provided. The purpose of evidence is to discover the... Let me know down below. Is the purpose of evidence to discover the mistakes, truth, or conditions or falsities about an occurrence? And if you didn't get truth, then you're incorrect, because the answer is truth. Yep. Alright, let me know down in the comments. Court decisions are based on evidence that either proves or disproves the facts of an occurrence, terms of occurrence, truth of occurrence, or extent of occurrence. If you didn't get facts, you're incorrect. Alright, evidence is the foundation of arguments presented by disagreements, facts, or inaccuracies. If you didn't get facts, you're incorrect. If you didn't get arguments, then you're incorrect. Alright, so the term evidence is used in court proceedings. Court decisions are based on evidence that either proves or disproves the facts of an occurrence. Evidence is a foundation of arguments presented by both sides during a trial. So it's basically an argument that you gotta win in a trial. Like, you don't want to lose it. Evidence is the source, outcome, result, or means of establishing proof. It's the means. Alright, so now we're going to talk about the types of evidence. Evidence can be separated into two basic categories: direct or indirect, circumstantial. Direct evidence comes from three sources: eyewitness accounts resulting from personal witness perceptions, hearing sounds that corroborate the testimony of an eyewitness, and personal touch that occurs when the eyewitness touches the person to determine life signs. Direct evidence is much stronger than indirect evidence and results in a stronger court case. It is considered the most important type of evidence. Indirect circumstantial evidence infers or presumes that the relevant fact is true by providing a different fact indirectly related to it. It is circumstantial evidence because it relates to circumstances surrounding the basic issue to be proved. Indirect evidence cannot be cannot prove a fact, but it can determine the probability of the occurrence being true. When dealing with indirect evidence, there are several factors to consider, including opportunity, motive, means, and circumstances. Indirect evidence must be reliable, and it is very important in cases where there is little to no direct evidence to support an issue. It can be very strong if there is no evidence to contradict it. However, it is generally used to support direct evidence. Inferences drawn from indirect evidence usually depend on cumulative effect. A number of indirect circumstantial incidents can determine guilt or innocence. Testimonial evidence is that which is testified to in court by a witness, either orally or by deposition. When a witness is interviewed, evidence is being gathered, but that witness is not under oath of the court. Documentary evidence is relevant information that is written, printed, typed, or otherwise recorded. It can include handwritten notes, letters, photos, tapes, or other documented materials. Physical/real evidence includes old tangible objects that can be presented in the court. Physical evidence consists of solids, liquids, or gases. It includes substances, prints, marks, and impressions that have relevant bearing to the case, including blood. Which of the following is a source of direct evidence? Testing. Pause the video, let me know I'm bloating. Which of the following is a source of direct evidence? Tasting, tasting, believing, smelling, or hearing. And the answer is hearing. Direct evidence comes from three sources. Eyewitness accounts resulting from personal witness perceptions, hearing sounds that corroborate the testimony of the eyewitness, and personal touch that occurs when the witness touches the person to determine life signs. Direct evidence is much stronger than indirect evidence and results from a stronger court case. It is considered the most important type of evidence. Indirect evidence can prove that the fact is true. True or false? Let me know down in the comments. Pause the video. And the correct answer is false. Indirect circumstantial evidence infers or presumes that a relevant fact is true by providing a different fact indirectly related to it. Circumstantial evidence is because it relates to circumstances surrounding the basic issue to be proved. Indirect evidence cannot prove a fact, but it can determine the probability of the occurrence being true. When dealing with the indirect evidence, there are several factors to consider, including opportunity, motive, means, and circumstances. Direct evidence is much stronger than indirect evidence and results in a stronger court case. It is considered the most important type of evidence. True or false? I think the answer is true, and the answer is true. Alright, sources of evidence. The four main sources of evidence are people, documents, objects, and personal observations. Like, sometimes they put the objects in like little evidence bags. People provide evidence as witnesses, victims, complaints, contacts, clients, suspects, police, investigators, and informants. They possess relevant information about an occurrence. So, like a witness. Public records. Documents provide evidence through information contained on paper, such as public records. They include all government information and organization books, business records, private records, relevant documents and writings, notes, letters, and other forms of written material. So, like, if there's some evidence that proves that they aren't guilty, then the court's going to have to take that in consideration, and they're probably just going to get let free. They're going to drop the case. Like, it's just some, like, it depends on the argument that's going on during the case. Objects provide evidence in a tangible form. All material objects that can be brought into court can be evidence, including any substance such as stains, prints, impressions, or marks. Personal observations of an investigator obtained throughout the course of an investigation are admissible as evidence. The knowledge accumulated from an investigator, either seen, discovered, or learned, or observed, may be included as evidence if that knowledge can be used to provide information concerning the credibility of people, the authenticity of documents, or the characteristics of material or physical objects. Personal observation evidence can include diagrams, photos, sketches, movies, and impression casts. Document provide evidence through information contained on paper. True or false? Let me know in the comments. Pause the video. And the answer is true. Objects provide evidence as tangible form that can include stains, prints, or marks. Let me know in the comments. The answer is true. And now we're doing admissible versus inadmissible evidence. And then we're going to get to the summary of the lesson. Evidence comes from complete when its own set of rules. Admissible evidence must be relevant, material, and incompetent. Relevant evidence tends to prove or disprove the fact of issue. It must be pertinent and shown to support or deny the fact pertaining to the outcome of the case, or it must be the truth more probable. Make the truth more probable. Relevant evidence may be excluded if it was obtained in an illegal manner, would cause undue prejudice to either party by shocking or inflaming a jury, would unfairly surprise the other party, would serve to confuse the issue, or would be too time-consuming. That's the rules. And material evidence is similar to relevant evidence. However, it is vital importance to the case. It provides the foundation and supports the probability or improbability of the truth or the fact. Competence evidence meets all legal requirements and is therefore admissible in court, and is evidence that is not barred by any stipulations and is relevant to the case. And now we're talking about hearsay advice. It is not generally advisable in court. Information presented by a third party is considered hearsay advice and is not considered reliable. And second-hand information is not always accurate. It includes all quoted oral statements or unauthenticated documents derived from anyone other than the witness testifying. For example, if an officer said that the person said something to him or her, what that person said to the officer would probably be admissible. If an officer said that person repeated something heard from the other person, that would not be admissible. There are instances where hearsay evidence may be admissible. The original person is not available to testify if the information is not available from any other source, and it has a direct bearing on the case, or if the trustworthiness of the witness is tested and verified, it may be considered acceptable. In some situations, the nature of material determines its admissibility. Spontaneous declarations and dying declarations fall into this category. Spontaneous declarations, referred to as res gestate, and are uttered on the spur of the moment. They are immediate, spontaneous exclamations, cries, shouts, or other verbal reactions caused by danger, incidents, threats, crimes, or other excitable circumstances. Dying declaration. When a person honestly believes that his or her life is ending, whether it actually happens or not, a dying declaration made by that person is admissible in court if it is relevant. Someone must be presenting during the dying declaration and testify in court that he or she heard the person's statement. Opinions are usually admissible in court. However, there are opinions that are accepted. If a doctor, professor, scientist, or some other person considered learned in a particular field provides the opinion, he would normally be allowed to testify as an expert in his related field. At times, a personal opinion may be admissible if it is related to the identification of certain items, such as that provided by an owner of stolen jewelry. Relevant evidence tends to prove or disprove an element, activity, or opinion or fact of the issue. Let me know in the comments. The answer is fact. And which one? Hearsay material. Hearsay material, illegal or opinion evidence proves the foundation of the case. The answer is material. And evidence that is secondhand information and not always accurate is called illegal evidence, legal evidence, material evidence, or hearsay evidence. The answer is hearsay evidence. And now we're going to get to the summary. So, wrapping up, the purpose of evidence is to discover the truth about facts of an occurrence. Evidence allows a person investigating a matter to arrive at the truth of the matter being investigated. Direct evidence includes eyewitness testimony, hearing, and touch. Indirect or circumstantial evidence presumes a fact that is true by proving a direct fact indirectly related to it. Evidence can be testimonial, documentary, and physical or real. Evidence derives from people, written or recorded documents, tangible objects, observations. For evidence to be admissible in court, it must be relevant, material, and competent. Alright, guys. Congratulations. You have now completed your lesson. And let me know in the comments if you liked it. Subscribe to my channel. Like the video. Share my videos. I love you all. And I'm actually going to help homeless people by liking and sharing and subscribing and commenting, because whenever I make my first $1 million this summer, I'm going to buy homeless people houses. So I love you all. Bye.